also contradict 8 of her friends and the statements by 2 professional counselors with whom she contemporaneously shared details of her relationship. By law, their testimony may serve as proper and admissible evidence to corroborate her side of this unfortunate story. Number 2, the evidence and testimony in this proceeding must be viewed as a whole. It cannot be compartmentalized. Please do not be misled into considering each event in isolation and then treating it separately. Remember, events and words that may seem innocent or even exculpatory in a vacuum may well take on a sinister or even criminal connotation when observed in the context of the whole plot. For example, we all agree that Ms. Lewinsky testified, quote, "No one ever told me to lie," unquote. When considered alone, this statement would seem exculpatory. In the context of other evidence, however, we see that this one statement gives a misleading inference. Of course, no one said, "Now, Monica, you go down there and lie." They didn't have to. Based upon their previous spoken and even unspoken words, Ms. Lewinsky knew what was expected of her. Surely, if the President were to come into the Senate floor and give testimony during this proceeding, he would not tell you that he honestly expected her to tell the truth about their personal relationship. After all, the purpose of her filing the false affidavit was to avoid testifying in the Jones case and discussing the nature of their relationship. If she had told the truth in that affidavit instead of lying, she would have been invited to testify immediately, if not sooner. Number 3, throughout our presentation of the facts, especially as it relates to the various illegal acts, I ask you to pay particular attention to what I call the big picture. Look at the results of those various acts, as well as who benefited. Please make a mental note now, if you can, and ask yourself always, as you look at each and one of these illegal acts that are presented to you, A, what was the result of that illegal act, and B, who benefited from that illegal act. I believe that you will find that the evidence will show that while the President's, quote, fingerprints may not be directly on the evidence proving these illegal acts, the results of the acts usually inure to the benefit of the President and the President alone. Subordinates and friends alike are drawn into this web of deceit. The President is insulated. Crimes are committed. Justice is denied. The rule of law is suspended. And this President is the beneficiary. Some examples. 1. Subpoenaed evidence disappears from Ms. Lewinsky's apartment and reappears under Ms. Curry's bed. What was the result of that? Who had the benefit of that? 2. Ms. Lewinsky files a false affidavit in the Jones case. What's the result of filing that false affidavit, and who benefited from that? Number 3, the President's attorney files the Lewinsky affidavit not knowing it was false, representing to the court that, quote, "there is absolutely no sex of any kind in any manner, shape, or form," unquote, while the President sits in the deposition and does not object to that, very silently sits in the deposition. What was the result of that, and who benefited from that filing of the affidavit? 4, and finally, Ms. Lewinsky, after months of job searching in New York City, is offered a job with a Fortune 500 company in New York City within 48 hours of her signing this false affidavit. Who shared the results of that with Ms. Lewinsky, and who obtained the benefit of that? Another example occurred in a meeting between the President and Ms. Lewinsky in July 4th, 1997, to be specific, when as a part of their conversation she mentioned that she had heard someone from Newsweek was working on a story about Kathleen Willey. The President had Ms. Lewinsky back for a visit on July 14th, some 10 days later, following his return from an overseas trip. And she was questioned about the Willey story, and specifically if Linda Tripp had been her source. Important to this point, the President then asked Ms. Lewinsky to try to persuade Ms. Tripp to call White House legal counsel Bruce Lindsay. The President told her to notify. And as you will learn from Mr. Hutchison, who will follow me with his presentation, this is very similar to the method of operation with another job the President requested be done, which in that case succeeded with a, quote, "mission accomplished," unquote. And I ask you to watch for that in Mr. Hutchison's presentation. I want to now rewind the clock back to November of 1995. We are here in Washington, where Ms. Lewinsky has been working at the White House since July of 1995. As you continue to listen to the evidence, From this point on November the 15th forward, remember that Ms. Lewinsky and the President were alone in the Oval Office workplace area at least 21 times. And I have listed these in chart form beginning again in November of 1995 and going through into 96 and into the early part of 1997, continuing through the year. During that time, they had at least 11 of the so-called salacious encounters there in the workplace at various times during the day and night. 3 in 1995, 5 in 1996, and 3 in 1997. They also had in excess of 50 telephone conversations, most of which appeared to have been telephone calls to and from Ms. Lewinsky's home, and I have scheduled all of these telephone calls to show you the 50-plus telephone calls. Also, they exchanged some 64 gifts, with the President receiving 40 of these gifts and Ms. Lewinsky receiving 24 of these gifts. And again, we have charts that reflect the receipt of both sets of gifts. And again, these charts will be here in the front, always available for your inspection. We also know that their affair began on November 15th. Interestingly, there's even a conflict here with the President. According to Ms. Lewinsky, they had never spoken to each other up to that point. Yet he asked this unknown intern into the private area of his office that day, the Oval Office, and kissed her. He then invited her back to return later that day when the two engaged in the first of these 11 acts of misconduct. Now, the contradiction is in the statement that the President relied upon in his grand jury testimony that's been referenced earlier, very carefully worded. In that statement, the President gave this testimony before the grand jury about meeting in this relationship, and he says, I quote, "I regret that what began as a friendship came to include this conduct," almost as if it had evolved over a period of time. So there's very clearly a conflict there. As Ms. Lewinsky's internship was ending that year, she did apply for and receive a paying job with the White House Office of Legislative Affairs. This position allowed her even more access to the Oval Office area. She remained a White House employee until April 1996, when she was reassigned to the Pentagon. The proof would show that Ms. Evelyn Lieberman, Deputy Chief of Staff at the time, believed that the transfer was necessary because Ms. Lewinsky was so persistent in her efforts to be near the President. Although Ms. Lieberman could not recall having heard any rumors linking her and the President, she acknowledged that the President was vulnerable to these kinds of rumors. While Ms. Lewinsky tried to return to work in the White House, her absence was appreciated by those on the President's staff who wanted to protect him. After she began her job at the Pentagon in April, there was no further physical contact with the President through the 1996 election and the remainder of that year. The two communicated by telephone and occasionally saw each other at public events. Their only attempt at a private visit in the Oval Office was thwarted because Ms. Lieberman was nearby. On December the 17th, she attended a holiday celebration at the White House and had a photograph made shaking hands with the President. However, the evidence establishes that in 1997, Ms. Lewinsky was more successful in arranging visits to the White House. This was because she used the discreet assistance of Ms. Curry, the President's secretary, to avoid the likes of Ms. Lieberman. Ms. Curry indicated that she did not want to know the details of this relationship. Ms. Curry testified that on one occasion when Ms. Lewinsky told her, quote, "As long as no one saw us, and no one did, then nothing happened," unquote. Ms. Curry responded, quote, "Don't want to hear it, don't say anymore, I don't want to hear anymore," unquote. Early on during their secret liaisons, the two had concocted a cover story to use if discovered. Ms. Lewinsky was to say that she was bringing papers to the President. The evidence will show this statement to be false. The only papers that she ever brought were personal messages having nothing to do with her duties or the President's. The cover story plays an important role in the later perjuries and obstruction of justice. Ms. Lewinsky stated that the President did not expressly instruct her to lie. He did, however, suggest the misleading cover story, and when she assured him that she planned to lie about that relationship, he responded approvingly. On the frequent occasions that she promised that she would always deny the relationship and always protect him for example, the President responded in her recollection, "That's good," or something affirmative, not "Don't deny it." The evidence will establish further that the two of them had, in her words, a mutual understanding that they would keep this private, so that meant deny it, and take whatever appropriate steps needed to be taken. When she and the President both were subpoenaed in the Jones case, Ms. Lewinsky anticipated that, as we had on every other occasion and every instance of this relationship, we would deny it. In his grand jury testimony, President Clinton acknowledged that he and Ms. Lewinsky might have talked about what to do in a non-legal context to hide their relationship, and that he might have said that Ms. Lewinsky should tell people that she was bringing letters to him or coming to visit Miss Curry. But he always stated that, "I never asked Ms. Lewinsky to lie." But neither did the President ever say that they must now tell the truth under oath. To the contrary, as Ms. Lewinsky stated, it wasn't as if the President called me and said, "You know, Monica, you're on the witness list, and this is going to be really hard for us. We're going to have to tell the truth and be humiliated in front of the entire world about what we've done," which I would have fought him on probably, she said. That was different. And by not calling me and saying that, I knew what that meant, according to Monica Lewinsky. In a related but later incident that Mr. Hutchinson may refer to, Monica Lewinsky testified that President Clinton telephoned her at home around 2 to 3 o'clock one morning on December the 17th, 1997, 2 to 2:30 a.m. He told her that her name was on the list of possible witnesses to be called in the Paula Jones lawsuit. When asked what to do if she was subpoenaed, the President suggested that she could sign an affidavit. Ms. Lewinsky indicated that she was at 100% sure that he had suggested that she might want to sign an affidavit. And she understood his advice to mean that she might be able to execute an affidavit that would not disclose the true relationship. And when Ms. Lewinsky agreed to that false affidavit, she told the President by telephone that she would be signing it and asked him if he wanted to see it before she signed it. According to Ms. Lewinsky, the President responded that he did not, as he had already seen about 15 others. Concurrent with these events I've just described, the evidence will further demonstrate that as Ms. Lewinsky attempted to return to work at the White House after the 1996 elections, she spoke with the President. According to Betty Curry, the President instructed Betty Curry and Marcia Scott, the Deputy Director of Personnel, to assist in her return to the White House. In the spring of 1997, Ms. Lewinsky met with Ms. Scott. She complained with subsequent notes to Ms. Scott and to the President about no progress being made with her getting back to the White House. On July 3rd of that year, she dispatched a more formal letter to the President, in fact, using the salutation, "Dear Sir," and raising the possible threat that she might have to tell her parents about why she no longer had a job at the White House if she didn't get another job. She also indicated her possible interest with a job in New York at the United Nations. The President and Ms. Lewinsky met the next day in what Ms. Lewinsky characterized as a very emotional visit, including the President scolding her that it was illegal to threaten the President of the United States. Their conversation eventually moved on to other topics, though, primarily her complaints about his failure to get her a job at the White House. Continuing Ms. Lewinsky's effort to return to work near the President, there was a July 16 meeting and a September 3rd telephone call with Ms. Scott. On the evening of September 30th, the President advised Ms. Lewinsky that he would have Chief of Staff Erskine Bowles help in the job search, and Bowles later passed this on to John Podesta, although each recall their involvement occurring earlier in the year. Just a few days later, however, her hopes of a job at the White House quickly ended. On October the 6th, she had a conversation with Linda Tripp, who told her that she would never return to work at the White House. And this was according to a friend of hers on the staff. Learning this secondhand was, according to Ms. Lewinsky, the straw that broke the camel's back. She decided to ask the President for a job in New York with the United Nations and sent him a letter to that effect on October the 7th. During an October 11th meeting with the President, he suggested that she give him a list of New York companies which interested her. She asked if Vernon Jordan might also help her. 5 days later, she provided the President with her wish list and indicated that she was no longer interested in the UN position, although she did receive an offer on November the 24th and declined it on January the 5th, 1998. After this meeting with the President, arrangements were made through the President and Ms. Curry for Ms. Lewinsky to meet Mr. Jordan. On the morning of November the 5th, 1997, Mr. Jordan spoke by telephone with the President for about 5 minutes and later met with Ms. Lewinsky for the first time for about 20 minutes. According to Ms. Lewinsky, Mr. Jordan told her that he had spoken with the President, that she came highly recommended, and that, quote, "we're in business," unquote. However, the evidence reflects that Mr. Jordan took no steps to help Ms. Lewinsky until early December of that year, after she appeared on the witness list in the Jones case. Actually, Mr. Jordan testified in his grand jury testimony that he had no recollection of even having met Ms. Lewinsky on November the 5th. And when he was shown documentary evidence demonstrating that his first meeting with Ms. Lewinsky occurred then, he acknowledged that such a meeting was entirely possible. So you can see that was not indeed a high priority for Mr. Jordan at that time until December. For many months, Ms. Lewinsky had not been able to find a job to her satisfaction, even without the perceived help of various people. Then in December of 1997, something happened which caused those interested in finding Ms. Lewinsky a job in New York to intensify their search. Within 48 hours of her signing this false affidavit in the Paula Jones case, Ms. Lewinsky had landed a job with a prestigious Fortune 500 company. It is anticipated that the attorneys for the President will present arguments which will contest much of the relationship with Monica Lewinsky. The President has maintained throughout the last several months that while there was no sexual relationship or sexual affair, in fact, there was some type of inappropriate intimate with Ms. Lewinsky at any time in the Oval Office. He also questions the definition of the word "is," and depends on what the word "is" means and how to answer a particular question. Further, we would expect the President to continue to disavow knowledge of why evidence detrimental to his defense in the Jones case was removed from Ms. Lewinsky's apartment and hidden beneath Ms. Curry's bed, or knowledge of how Ms. Lewinsky found herself with an employment offer in New York virtually at the same time she finally executed an affidavit in the Jones case. Unfortunately for your search for the truth in these proceedings, the President continues today to parse his words and use legal hair-splitting in his defense. I cite for your consideration his answer filed with this body just days ago. For instance, 1. Responding in part to the impeachment Article 1, the President persists in a wrong-headed fashion with his legal hair-splitting of the term sexual relations, which permits him to define that term in such a way that in the particular salacious act that we're talking about here, one person has sex and the other person does not. As a graduate of one of the finest law schools in America, and as a former law professor and attorney general for the state of Arkansas, the President knows better. Number 2, and I have this statement here extracted out of the President's answer to this proceeding. Responding to both articles of impeachment, 1 and 2, the President now would have you to believe that he was not focusing, the quote, was not focusing when his attorney, Bob Bennett, was objecting during the deposition and attempting to cut off a very important line of questioning to the President by representing to Judge Wright that Ms. Lewinsky's affidavit proved that there's no need to go into this testimony about the President's life. This affidavit proves there is absolutely no sex of any kind, in any manner, shape, or form. And remember, this is the same President who now pleads he lost his focus during this very important part of this deposition. This is the very same President who is renowned for his intelligence and his ability to compartmentalize, to concentrate, to focus on whatever matter is at hand. And now he comes before this Senate, to each one of you in his answer, by and through his attorneys, and pleads that he simply wasn't paying attention at this very important part during his own deposition. In Tennessee, we have a saying for situations like that. It's "that dog won't hunt." Number 3, in further response to Article 1, which the President effectively admits his guilt to obstruction as I read this. His pleadings refer to the President himself, and he states, he, the President, truthfully explained to the grand jury his efforts to answer the questions in the Jones deposition without disclosing his relationship, disclosed my relationship with Ms. Lewinsky. Then at the bottom of the same page, he says that he denies that he attempted to impede the discovery of evidence in the Jones case. Now think about this with me a minute. The purpose of basically the purpose of the Jones deposition of the President was to secure truthful testimony about these kinds of pattern and practice witnesses, and therein discover the likes of Monica Lewinsky. That's the purpose of being there. And the President has just admitted in his answer that he purposely answered questions so as not to disclose his relationship with Ms. Lewinsky. Said another way, he intentionally answered questions to avoid the discovery of one of his female employees with whom he was sexually involved. And that is precisely, folks, that's precisely what impeding the discovery of evidence is. So I'd ask you to, if you get an opportunity, to look at that very closely. Number 4, in his answer to Article 2, the President denies that he encouraged Monica Lewinsky to execute a false affidavit in the Jones case. When everything is said and done, Ms. Lewinsky had no motivation, had no reason whatsoever to want to commit a crime by willfully submitting a false affidavit with a court of law. She really did not need to do this at that point in her life. But this 20-something young lady was listening to the most powerful man in the United States, a man she greatly admired, and hearing him effectively instruct her to file a false affidavit to avoid having to testify about their relationship. And in order to do that, she had to lie about the physical aspects of their relationship. According to her, the President didn't even want to see that actual affidavit because he had seen 15 more just like it, and as such, knew it would be right. Number 5, in an additional response to Article 2, the President answers and asserts that he, quote, believed that Ms. Lewinsky could have filed a limited but truthful affidavit that might have enabled her to avoid having to testify in the Jones case. Now, that is an incredible statement. That is an incredible statement, given the fact that the President knew firsthand of the extent of their sexual relationship, and he also knew that the Jones discovery efforts were specifically after that type of conduct. Even with the best of legal hair splitting, it's still difficult to envision a truthful affidavit from Ms. Lewinsky which could have skirted the issue enough to avoid testifying. And if you really believe the President had this belief, don't you think he would have accepted Ms. Lewinsky's offer to review her affidavit and perhaps share this bit of wisdom he had with her before she signed it and lied? After all, in this answer he just filed, he says he had an out for her. He had a way for her to have the best of both worlds, not to have to lie and still avoid testifying in the Jones case. Why didn't he share that with her when she gave him the opportunity, if he in fact had such an idea in those days? I suggest to you that perhaps that's a recent idea. But even if for some reason you don't believe Ms. Lewinsky offered to share that affidavit with him, don't you think it still would have been in the President's best interest to give Ms. Lewinsky his thoughts before she violated the law with a completely false affidavit? Now indeed is the time to stop the legal gymnastics and the legal hair splitting and to deal with these charges and these facts appropriately. As a House manager, I believe that I can speak for all of us out of a sense of fairness and again request that we and the President be permitted to call witnesses. I would submit that the state of the evidence is such that unless and until the President has the opportunity to confront and cross-examine witnesses like Ms. Lewinsky and himself to testify if he desires, there cannot be any doubt of his guilt on the facts. A reasonable and impartial review of this record as it presently exists demands nothing less than a guilty verdict. And while it's been the consistent defense of the White House to be inconsistent, it still comes as something of a surprise that the President has not made a stronger case for calling witnesses. Before now, he has aggressively sought the opportunity to challenge the truth and the veracity of witnesses in these impeachment proceedings. During the hearings in the House, which many believe are analogous to a grand jury proceeding, the President's defenders and his attorneys consistently complained of the failure to call witnesses and the lack of fairness in due process. Almost every day, there were partisan attacks from the White House and its emissaries who were dispatched throughout the media talk shows with the same complaints of no witnesses. And always, our measured response was a calm assurance that there would be witnesses called during the trial phase in the Senate. Is there any doubt?
You are watching NBC News live coverage, the Senate trial of President Clinton, the factual aspects of the case being laid out by one of the 13 House managers, Republican Congressman Ed Bryant of Tennessee.
And weigh the testimony and the credibility of the fact witnesses. In recent days, some have publicly asserted that the House was hypocritical or is hypocritical because we didn't call some of the fact witnesses it now asked to call in the Senate. We asked to call in the Senate. But any allegation of hypocrisy certainly appears to miss the point that the writers of our Constitution never contemplated two separate trials for an impeachment proceeding. But now we would respectfully request is the time, or suggest is the time for witnesses. All Americans, including the President, are entitled to enjoy a private family life free from public or governmental scrutiny. But the privacy concerns raised in this case are subject to limits, and three of these I will briefly discuss. First, the first limit was imposed when the President was sued in federal court for alleged sexual harassment. The evidence in such litigation is often personal. At times, that evidence is highly embarrassing for both the plaintiff and the defendant. As Judge Wright noted at the President's January 1998 deposition, I have never had a sexual harassment case where there has not been some embarrassment. Nevertheless, Congress and the Supreme Court have concluded that embarrassment-related concerns must give way to the greater interest in allowing aggrieved parties to pursue their claims. Courts have long recognized the difficulties of proving sexual harassment in the workplace, inasmuch as improper and unlawful behavior often takes place in private. To excuse a party who lied or concealed evidence on the ground that the evidence covered only personal or private behavior would frustrate the goals that Congress and the courts have sought to achieve in enacting and interpreting the nation's sexual harassment laws. That is particularly true when the conduct that is being concealed, sexual relationship in the workplace between a high official and a young subordinate employee, itself conflicts with these goals. Second, the second limit was imposed when Judge Wright required disclosure of the precise information that is in part the subject of this hearing today. A federal judge specifically ordered the President on more than one occasion to provide requested information about relationships with other women, including Ms. Lewinsky. The fact that Judge Wright later determined the evidence would not be admissible at the trial or still later granted judgment in the President's favor does not change the President's legal duty at the time he testified. Like every litigant, the President is entitled to object to discovery questions and to seek guidance from the court if he thought those questions were improper. But having failed to convince the court that his objections were well-founded, the President was duty-bound to testify truthfully and to testify fully. Perjury and attempts to obstruct the gathering of evidence can never be an acceptable response to a court order, regardless of the eventual course or outcome of that litigation. The Supreme Court has spoken forcefully about perjury and other forms of obstruction of justice. Quote, "In this constitutional process of securing a witness's testimony, perjury simply has no place whatsoever. Perjured testimony is an obvious and flagrant affront to the basic concepts of judicial proceedings. Effective restraints against this type of egregious offense are therefore imperative. The insidious effects of perjury occur whether the case is civil or criminal."
Here again, Congressman Asa Hutchinson.
Or impede the proper functioning of our system of justice. It is a criminal offense, a felony, and it has historically been an impeachable offense. Let me first say, it is not a crime nor an impeachable offense to engage in inappropriate personal conduct, nor is it a crime to obstruct or conceal personal embarrassing facts or relationships. It might be offensive, but there are no constitutional consequences. But as we go through the facts of the case, the evidence will show in this case that there was a schemed, that was developed to obstruct the administration of justice, and that is illegal. And the obstruction of justice is of great consequence and significance to the integrity of our nation when committed by anyone, but particularly by the chief executive of our land, the President of the United States. Now, Mr. Bryant took us factually up to a certain point pertaining to the job search. And this is chart number 1 that you have before you. And this puts it in perspective a little bit, and just for a brief review. If you go back in the calendar, back into October, that's when Ms. Lewinsky sends the President her wish list for a list of jobs. And then shortly after that, Ms. Curry faxes Lewinsky the resume to Ambassador Richardson. And Ambassador Richardson gets involved in the job search. October 30, the President promised to arrange a meeting between Lewinsky and Jordan. This was set up, if you go to November, in November. It was actually November 5, but preceding that, there was a job offer at the UN extended to Ms. Lewinsky. Now, Ms. Lewinsky decided that she was not interested in a job at the United Nations. She wanted to go into the private sector, and so that was the purpose on November 5 of the meeting between Jordan and Lewinsky. And that's when Mr. Jordan says, we're in business. But the facts will show that there was nothing really done in November, and that's when I will get in a little bit more to my presentation, and then we'll go into December when some things happened there that picked up speed on this issue. The obstruction for our purposes started on December 5, 1997, and that is when the witness list from the Paula Jones case was faxed to the President's lawyers. At that point, the wheels of obstruction started rolling, and they did not stop until the President successfully blocked the truth from coming out in the civil rights case. These acts of obstruction included attempts to improperly influence a witness in the civil rights case, that's Monica Lewinsky, the procurement and filing of a false affidavit in the case, unlawful attempts to influence the testimony of a key witness, Betty Curry, the willful concealment of evidence under subpoena in that case, which are the gifts of December 28, and illegally influencing the testimony of witnesses, that is, the aides that testified before the grand jury of the United States. Each of these areas of obstruction will be covered in my presentation today. As I said, it began on Friday, December 5, when the witness list came from the Paula Jones case. Shortly thereafter, the President learned that the list included Monica Lewinsky. This had to be startling news to the President, because if the truth about his relationship with a subordinate employee were known, the civil rights case against him would be strengthened, and it might have totally changed the outcome. But to compound the problem, less than a week later, Judge Wright, the federal district judge in Arkansas, on December 11th, issued an order. And that order directed that the President had to answer questions concerning other relationships that he might have had during a particular time frame with any state or federal employee. And when I say relationships, I'm speaking of sexual relationships. And so Judge Wright entered the order that is not in your stack, but I have it here. It is filed on December 11th in the district court in Arkansas, and directs the President that he has to answer those questions within a time frame, as Mr. Bryant said, which is typical in a civil rights case of this nature. Now, the White House knew that Monica was on the witness list. The President knew that it was likely that she would be subpoenaed as a witness, and that her truthful testimony would hurt his case. What did the President do? What he had to do was he made sure that Monica Lewinsky was on his team and under control. And then on December 17th, the President finally called Ms. Lewinsky to let her know she was on the list. This was a call between 2 a.m. and 2:30 a.m. in the morning. Now, what happened in the time between the President learning Monica Lewinsky was on the list and when he notified her of that fact on December 17th is very important. The President, during that time frame, talked to his friend, his confidant, and his problem solver, Vernon Jordan. Mr. Jordan had come to the President's rescue on previous occasions. He was instrumental in securing consulting contracts for Mr. Webb Hubbell, while Mr. Hubbell was under investigation by the independent counsel. They go to that point right before Mr. Hubbell announced his resignation from the Justice Department. During that time frame, there was a meeting at the White House in which the President, the First Lady, and others were present. After that meeting, Vernon Jordan agreed to help obtain financial assistance for Mr. Hubbell. Mr. Jordan then introduced Mr. Hubbell to the right people. The introduction was successful, and Mr. Hubbell obtained a $100,000 contract. The right people that Mr. Jordan contacted happened to be the same right people for both Mr. Hubbell and ultimately for Monica Lewinsky, which is the parent company of Revlon. And so the President was aware that Mr. Jordan had the contacts and the track record to be of assistance to the President in delicate matters. Now let's go back a little. Monica Lewinsky had been looking for a good-paying and high-profile job in New York since the previous July, as I pointed out. She had been offered a job at the UN, but she wanted to work in the private sector. She wasn't having much success, and then in early November, it was Betty Curry who arranged a meeting with Vernon Jordan, which ultimately was on November 5. At this meeting, Ms. Lewinsky met with Mr. Jordan for about 20 minutes. Now let's refer to Mr. Vernon Jordan's grand jury testimony on that meeting that occurred on November 5. And you have that, it should be your chart number 2 or exhibit 2. As Mr. Jordan testified before the federal grand jury on March 3, 1998, in reference to the November 5 meeting, he testifies, "I have no recollection of an early November meeting with Miss Monica Lewinsky. I have absolutely no recollection of it and have no record of it." He goes on to testify at page 76 of the grand jury testimony, question, "Is it fair to say that back in November, getting Monica Lewinsky a job on any fast pace was not any priority of yours?" His answer, "I think that's fair to say." Now, let's stop there for a moment. What happened as a result of this meeting? No action followed whatsoever. No job interviews were arranged, and there were no further contacts with Mr. Jordan. Mr. Jordan made no effort to find a job for Miss Lewinsky for over a month. Indeed, it was so unimportant to him that he had no recollection of that early November meeting, and in fact, he testified that finding her a job was not a priority. And then you will see that during this time frame, the President's attitude was exactly the same. And so look at the same Exhibit 2, the last item on that chart, where it refers to Monica Lewinsky's grand jury testimony. And there, she is referring to a December 6 meeting with the President. "I think I said that I was supposed to get in touch with Mr. Jordan the previous week and that things did not work out and that nothing had really happened yet on the job front." And the question was, did the President say what he was going to do? The answer, I think he said he would, this was sort of typical of him to sort of say, "Oh, I'll talk to him, I'll get on it." And so you can see from that it was not a high priority for the President either. It was, "Sure, I'll get to that, I will do that." And it was clear from Monica Lewinsky that nothing was happening. But then the President's attitude suddenly changed. What started out as a favor for Betty Curry dramatically changed after Miss Lewinsky became a witness. And the judge's order was issued again on December 11th. And at that time, the President talked personally to Mr. Jordan and requested his help in getting Miss Lewinsky a job. And that would be, again, back on Exhibit 2 on that chart, the third item of testimony there, back to Mr. Jordan, his grand jury testimony, May 5th of 1998. The question is, but what is also clear is that as of this date, December 11, you are clear that at that point you had made a decision that you would try to make some calls to get help, to get her a job. His answer, there is no question about it. And so what triggered, let's look at the chain of events. The witness list came in, the judge's order came in, that triggered the President into action, and the President triggered Vernon Jordan into action. That chain reaction here is what moved the job search along. Now, if we had Mr. Jordan on the witness stand, which I hope to be able to call Mr. Jordan, you would need to probe where his loyalties lie, listen to the tone of his voice, look into his eyes, and determine the truthfulness of his statements. You must decide whether he is telling the truth or withholding information. And so let's go to Exhibit 3 in your booklet. Again, recalling Mr. Jordan. He testifies about that meeting. He testifies on his March 3, 1998 grand jury testimony. I am certain after the 11th that I had a conversation with the President. And as a part of that conversation, I said to him that Betty Curry had called me about Monica Lewinsky. And the conversation was that he knew about her situation, which was that she was pushed out of the White House, that she wanted to go to New York, and he thanked me for helping her. Remember what else happened on that day again. That is the same day that Judge Wright ruled that the questions about other relationships could be asked by the Jones attorneys. Now let's go back again to Mr. Jordan's testimony. What does he say about the involvement of the President of the United States in regard to these jobs? If you look at Exhibit 4 that is in your booklet, this is again Vernon Jordan's grand jury transcript of June 9, 1998. Now the question is on a different issue. The question is about why did he tell the White House that Frank Carter was the attorney for Monica Lewinsky, that Vernon Jordan arranged and introduced to Monica Lewinsky. He was hired, and whenever at that point that he was terminated, then Vernon Jordan notified the President. And so the question relates to that. Why are you trying to tell someone at the White House that this happened? Carter had been fired. Answer, thought they had a right to know. Why? And here the answer is what is critical for my point. The President asked me to get Monica Lewinsky a job. I got her a lawyer, the Drudge Report is out, and she has new counsel. I thought that that was information that they ought to have. The President asked me to get Monica Lewinsky a job. Clear, straightforward testimony, no doubt about it. And then go on down to page 58 of his grand jury testimony of June 9th. The question, why did you think the President needed to know that Frank Carter had been replaced? Answer, information. He knew that I had gotten her a job. He knew that I had gotten her a lawyer. Information. He was interested in this matter. He is the source of it coming to my attention in the first place. He is the source of it coming to my attention in the first place. Remember, he had already met with Betty Curry. Nothing was happening in the November time frame. Nothing was happening. Vernon Jordan it was not a priority. And then the President of the United States called him, and it became a priority. And that is who he was acting for in trying to get Monica Lewinsky a job. At this point, we do not know all that the President was telling Vernon Jordan. But we do know that there were numerous calls back and forth between Mr. Jordan and the President. There were numerous calls being made by Mr. Jordan in behalf of Monica Lewinsky searching for a job. And that despite the fact that Monica Lewinsky did not know that she was a witness, she did not know she was a witness, the President knew that she was a witness during his intensified efforts to get a job. Now the President's counselors have made a defense that the job search started before Monica Lewinsky was a witness, and there was nothing wrong with that. My response to that is, it is true, there is nothing wrong with a public official, under the right circumstances, helping someone get a job. And what might have started out being innocent, if you accept that argument, crossed the line whenever it was tied and interconnected with the President's desire to get a false affidavit from Monica Lewinsky. And whenever the job is out there and procuring the false affidavit, you will see that they are totally interconnected, intertwined, interrelated, and that's where the line is crossed into obstruction. For example, when the President was waiting on Ms. Lewinsky to sign the false affidavit in the Jones case, during the critical time in January, a problem developed. The job interviews were unproductive despite the numerous calls by Mr. Jordan. On one particular day, Monica called Mr. Jordan and said the interview with Revlon did not go well. Mr. Jordan, what did he do? He picked up the phone to the CEO, the president of the company, Mr. Perlman, to, as Vernon Jordan testified, make things happen if they could happen. That is the request from Mr. Jordan to the CEO of a country after a job interview with Monica Lewinsky did not go well. What happened? Things happened. He did. He made things happen. Monica Lewinsky got a job. The affidavit was signed, and the President was informed by Mr. Jordan through Betty Curry that the mission was accomplished. End quote. The question here is not why did the President do a favor for an ex-intern, but why did he use the influence of his office to make sure it happened? The answer is that he was willing to obstruct, impede justice by improperly influencing a witness in order to protect himself in a civil rights case. The next step in the obstruction is the false affidavit, and this is directly related to the job mission. The President needed the signature of Ms. Lewinsky on the false affidavit, and that was assured by the efforts to secure her a job. Again, the President brought Ms. Lewinsky into the loop on December 17th, over 10 days after the witness list was received by the President. Now, the President was ready to tell Monica the news, and that time frame is important. He gets the witness list. He could have called Monica Lewinsky immediately, but he waited 7 days because he needed to make sure the job situation was in gear. And in fact, the day after, if you look back on Exhibit 1, you'll see that the day after the December 17th time frame that she was informed that she was on the witness list, the next day they already had lined up job interviews for her, so she felt confidence. But she was notified on December 17th. Between 2 and 2:30 a.m., her phone rang. It was the President of the United States. The President said that he had seen the witness list in the case and her name was on it. Ms. Lewinsky asked what she should do if subpoenaed, and the President responded, quote, "Well, maybe you can sign an affidavit," end quote. Well, how would this work? Both parties knew that the affidavit would need to be false and misleading in order to accomplish the desired result. Clearly, truthful testimony by Monica Lewinsky would make her a witness, would not keep her away from testifying. Only a false affidavit would avoid the deposition. And so let me look at what I've marked as Exhibit 4.1, which is just a review of the key dates on this job search. Again, November 5th was the first meeting between Jordan and Lewinsky. In November, nothing happened. According to Jordan, not a high priority. December 5th, the President receives the witness list. The 11th, things intensified with Judge Wright's order. The 11th, the President talks to Mr. Jordan about the job for Monica. He gets into action. On the 17th, they're ready to tell Monica that she is on the witness list, and then on the 19th, she is actually served with a subpoena. And so, again, remember that after she was finally notified, it was the next day that she had the job interviews. Now, still, we're going to spend some time on this December 17th, the conversation, the day that Monica Lewinsky was notified that she was on the witness list. And during that conversation, the President had a very pointed suggestion for Ms. Lewinsky, and a suggestion that left no doubt about his purpose and the intended consequences. He did not say specifically, go in and lie. And this is something that you will hear that, and Monica Lewinsky testified in her grand jury testimony, the President never told me to lie. Well, how do you tell people to lie? You can tell them the facts that they can use that would in substance be a false statement, or you can say, go in and lie and make up your own false testimony. The President chose to give her the ideas as to what she could testify to that would be false, but he never said the words, you need to go in and lie. And so what he did say to her was, quote, you know, you can always say you were coming to see Betty or that you were bringing me letters, end quote. That, ladies and gentlemen of the Senate, is a false representation, is a false statement that he is telling Ms. Lewinsky to utter. Now remember, at this point, the President knows she's a witness, and what does he do? As evidenced by the testimony of Monica Lewinsky, he encourages her to lie, to say, you can always say you were coming to see Betty or that you're bringing me letters. It should also be remembered that the President when questioned about encouraging Monica Lewinsky to lie, has denied these allegations, and therefore there is certainly a conflict in the testimony. It is our belief that Ms. Lewinsky's testimony is credible and that she has the motive to tell the truth because of her immunity agreement with the independent counsel, where she gets in trouble only if she lies, whereas the President has the motive to cover up and to testify falsely. In order to understand the significance of this statement made by the President, it is necessary to recall the cover stories that the President and Ms. Lewinsky had previously concocted in order to deceive those people who might inquire. It was to deceive those people that they worked with. The difference in the initial cover stories, though, to protect the President and Monica from an embarrassing personal relationship from friends and co-workers and the media, now it is in a different arena, with the pending civil rights case and Ms. Lewinsky being on the witness list. Despite the legal responsibilities, the President made the decision to continue the pattern of lying which ultimately became an obstruction of the administration of justice. We're still on December 17th, when the President called Monica at 2 a.m. on that particular day to tell her she was on the witness list. He made sure to remind her of the cover stories. Ms. Lewinsky testified that when the President brought up the cover stories, she understood that the two of them would continue their pre-existing pattern of deception. And it became clear that the President had no intention of making his relationship with a subordinate federal employee an issue in that civil rights case, no matter what the federal courts told him he needed to answer. And he would use lies, deceit, and deception to carry out that purpose. It's interesting to note that the President, when he was asked by the grand jury whether he remembered calling Monica Lewinsky at 2 a.m. on that December 17th date, he responded, quote, "No, sir, I don't, but it is quite possible that that happened," end quote. And when he was asked whether he encouraged Monica Lewinsky to continue the cover stories of coming to see Betty or bringing the letters, he answered, quote, "I don't remember exactly what I told her that night," end quote. This is not a denial, and therefore I believe you should accept the testimony of Monica Lewinsky. If you say in your mind, well, I'm not going to believe her, then you should first give us the opportunity to present this witness so that you as jurors could fairly and honestly determine her credibility. As expected, 2 days later, on December 19th, Ms. Lewinsky received the subpoena to testify in the Jones case. And this sets about an immediate flurry of activity. There is a series of telephone calls between Ms. Lewinsky, Vernon Jordan, the President, and his staff. You will see this pattern of telephone calls repeated and generated at any point in time when it appears that the truth may be told in the civil rights case. Now let's look at Exhibit 5, which is the activity on Friday, December 19th. This is the day that Monica Lewinsky is served with a subpoena. Now, if you look, after Mr. Jordan is notified that Monica Lewinsky is served with a subpoena, what does he do? The 351, 352 notation, Jordan telephones the President and talks to Deborah Schiff, his assistant. So the subpoena is issued, Monica calls Jordan, Jordan immediately calls the President. He makes some other telephone calls. Lewinsky that day meets with Mr. Jordan and requests that the Jordan notify the President about her subpoena. And this is at 4:47 p.m. Presumably in the middle of that meeting, at 5:01 p.m., the President of the United States telephones Mr. Jordan. And Jordan notifies the President about Ms. Lewinsky's subpoena. And then that's whenever he arranges for Ms. Lewinsky's attorney. Jordan telephones the attorney Frank Carter for the representation. And that night, Vernon Jordan goes to the White House later that evening to meet privately with the President on these particular issues. Now, in that meeting, and I'm speaking of the meeting that happened late that night at the White House, Mr. Jordan told the President again
the evidence
that Ms.
getting
Lewinsky
very close to home for the President right now. Republican Congressman Asa Hutchinson of the state of Arkansas continuing his painstaking review of the evidence in the case as one of the 13 House managers As he goes through as the latest presenter, there will be, perhaps time permitting, one more as you are watching NBC News special coverage of the trial of the president before the Senate.
And aides. The president stated in his deposition that he does not recall that meeting. But you should remind yourselves of the testimony and description provided by Vernon Jordan.
It is now 4 o'clock here in the East, with the Dow Jones, as you see, down over 220 points, a crippling winter storm on the East Coast. The chief story, our focus today, the live ongoing coverage, the impeachment trial of Bill Clinton in the Senate. Let's listen in. Republican Congressman Asa Hutchinson presenting evidence on the topic of obstruction.
And so the president and his team had some time to work. The work was not the business of the nation, but it was the distraction of self-preservation in the civil rights case. Under the plan, Mr. Jordan would be the buffer. He would obtain an attorney, which was Mr. Carter, and that attorney would keep Mr. Jordan informed on the progress of the representation, including reviewing a copy of the affidavit, knowing about the motion to quash, and the general progress of the representation. All along the way, when Mr. Jordan gets information, what does he do with that? Mr. Jordan keeps the president informed both about the affidavit and the prospects of the job in New York, on which Ms. Lewinsky was totally dependent on the help of her friends in high places. Now, let me go back again. There is nothing wrong with helping someone get a job. But we all know there's one thing forbidden in public office. We must avoid a quid pro quo. That is, this is for that. But Vernon Jordan testified that he kept the president informed on the status of the false affidavit, the job search, and the status of Ms. Lewinsky's representation. Why? Is this just idle chatter with the President of the United States? Or are these matters the President is vitally interested in and, in fact, coordinating? Mr. Jordan answers this question himself at page 25 of his grand jury testimony, where he testified, quote, "I knew the President was concerned about the affidavit and whether or not it was signed. He was, obviously." And that was his March 5th, 98 grand jury testimony. The President was concerned not just about the affidavit, but specifically whether it was signed. The President knew that Monica was going to make a false affidavit. He was so certain of the contents that when Monica Lewinsky asked if he wanted to see it, he told her no, that he had seen 15 of them. Besides, the President had suggested the affidavit himself, and he trusted Mr. Jordan to be certain to keep things under control. In fact, that was one of the main purposes of Mr. Jordan's continued communication with Monica Lewinsky's attorney, Frank Carter. Even though Mr. Jordan testifies at one point he never had any substantive discussions on the representations of Mr. Carter, he contradicts himself in his March 3 grand jury testimony, where he states, quote, "Mr. Carter at some point told me," this is after January, "that she had signed the affidavit, that he had filed a motion to quash her subpoena, and that, there was no reason for accountability, but he reassured me that he had things under control," end quote. Mr. Jordan was aware of the substance of the drafting of the affidavit, the representation, the motion to quash, even had a part in the redrafting. This was clearly important to Mr. Jordan, and it was clearly important to the President. Now let's go to the time when the false affidavit was actually signed, January 5, 98, and these will be Exhibits 7, 8, and 9 that is in front of you. Let's go to January 5. This is sort of a summary of what happens on that day. Ms. Lewinsky meets with her attorney, Mr. Carter, for an hour. Mr. Carter drafts the affidavit of Ms. Lewinsky that's on the deposition. And then let's go to the second paragraph. Ms. Lewinsky telephones Betty Curry, stating that she needs to speak to the President. This is about an important matter, specifically that she was anxious about something she needed to sign an affidavit. Frank Carter drafts the affidavit. She's concerned about it. She calls the President. The President returns Monica Lewinsky's call. Big question, should the President return Monica Lewinsky's call? He does. That day, quickly, Lewinsky mentions the affidavit she'd be signing, offers to show it to the President, and that's where he says no, that he's seen 15 others. Thank you. Let's go to the next day. The next exhibit, January 6th. On this particular day, Monica Lewinsky picks up the affidavit, the draft affidavit, at 2:08 to 2:10 p.m. and delivers that affidavit to whom? Mr. Jordan. That's after she got it. Delivers it to Jordan. And then at 3:26 p.m., Mr. Jordan telephones Mr. Carter. At 3:38, Mr. Jordan telephones Nancy Hernwright at the White House. Again, Mr. Jordan telephones Lewinsky about the draft affidavit. And at 3:49, you'll see in red that both agree to delete a portion of the affidavit that created some implication that maybe she had been alone with the President. And so Mr. Jordan was very involved in drafting the affidavit and the contents of that. And then at 4:19, presumably this is in response to some of the calls by Mr. Jordan earlier in the day, the President telephones Mr. Jordan. And they have a discussion, and then Mr. Jordan telephones Mr. Carter, and the conversations go back and forth. At the end of the day, Mr. Jordan telephones the White House. And so the affidavit is still in the drafting process. Go to the next day, Exhibit 9. Here, Monica signs the affidavit. At 10 a.m., Ms. Lewinsky finds the false affidavit at Mr. Carter's office. Then what does she do? She delivers the signed affidavit to Mr. Jordan. And then what does he do? The usual. At 11:58, Mr. Jordan telephones the White House. At 5:46, Mr. Jordan telephones the White House. At 6:50, Mr. Jordan telephones the White House and tells the President that Ms. Lewinsky signed the affidavit. Is this important information for the President to know? He was vitally interested in it. And then go to the next day, Exhibit 10, January 8th. After the affidavit is signed, what is important the next day? That the other part of the arrangement, that she has the job interview with McAndrews in New York. And she had that job interview. The only problem was it went poorly. The interview went very poorly, and so at 4:43 p.m. on this particular day, Ms. Lewinsky telephones Jordan and advises that the New York interview went very poorly. And so what does Mr. Jordan do? Mr. Jordan telephones Ron Perlman, the CEO, the subsidiary of Revlon, to make things happen if they could happen. And what does he do next? Jordan telephones Lewinsky saying, I'm doing the best I can to help you out. And they set up another interview for the next day. Jordan telephones the White House counsel's office. And then in the evening, Revlon in New York telephones Lewinsky to set up a follow-up interview. They said the first interview didn't go well, but because Mr. Jordan intercedes, and he intercedes, why? Because the false affidavit has been signed. We want to make sure all this is carried out. And then at 9:02, Lewinsky telephones Jordan about the Revlon interview in New York. That presumably, hopefully, it went better on that particular day. And then on January 9, Exhibit 11, Monica is confirmed that she has the job. Lewinsky is offered the Revlon job in New York and accepts. Lewinsky telephones Jordan, and then at 4:14, Jordan notifies Curry, calls Betty Curry and says, mission accomplished, and requests that she tell the President. Jordan notifies the President of Lewinsky's New York job offer. Says, thank you very much from the President. And then that evening, the President telephones Curry, and so on. But the President is notified that the job has been secure, mission is accomplished. Now, let me ask you a question after I've gone through these exhibits. Would Mr. Jordan have pushed for a second interview without cooperation on the affidavit? Would Monica Lewinsky have received the support in securing a job if she had said, I don't want to sign an affidavit, I'm just going to go in there and tell the truth. Whatever they ask me, I'm going to answer, I'm going to tell the truth. Does anyone in this room believe that she would have been granted, that Mr. Jordan had made that call to get that second interview, that she would ever had the help from her friends in high places. And now, the affidavit has been signed, the job is secure, Monica Lewinsky is on the team, and the President of the United States is armed for the deposition. So let's move there. Just how important was Monica Lewinsky's false affidavit to the President's deposition? Well, let's look to see what did the President's attorney, Robert Bennett, say about that affidavit to the federal judge during the deposition. That false affidavit allowed Mr. Bennett, the attorney for Mr. Clinton, when talking about the question of whether there's a relationship between the President and Ms. Lewinsky, it allowed him to assert, quote, "There is absolutely no sex of any kind in any manner, shape, or form with President Clinton," end quote. And that is the statement of Robert Bennett, that his representation to the court about that relationship, it is a representation that he had to later, probably based upon his own professional embarrassment, he had to withdraw and to correct that inaccurate part of the record. When questioned by his own attorney in the deposition, the President stated specifically the key paragraph of Ms. Lewinsky's affidavit was, quote, "absolutely true." And that paragraph 8 of her affidavit states, "I have never had a sexual relationship with the President." Now, if it enters your mind at this point as to what was meant by sexual relationship, please remember that this affidavit was drafted upon common understanding of that phrase at that point, and not based upon any definition used in the deposition of the President. I'm sure it was the President's hope and belief that the false affidavit used in the deposition to bolster his own testimony would be the end of the matter. But that was not the case. We know in life, one lie leads to another. Well, so it is when we attempt to thwart the administration of justice. One obstruction leads to another. And now, we move to another key witness, Betty Curry. By the time the President concluded his deposition, he knew there were too many details out about his relationship with Ms. Lewinsky. He knew that the only person that could probably be talking was Ms. Lewinsky herself. He knew the cover story that they had carefully created, converted into the false statements in the affidavit, was now in jeopardy. It had to be backed at this point by the key witnesses, Monica Lewinsky and Betty Curry. After the deposition, the President needed to do two things. He had to contact Ms. Lewinsky to see if she was still on the team. But he also had to make sure his secretary, Betty Curry, would lie to protect him. And so let's look at how the concern became a frenzied and concerted effort to keep the holes plugged in the dike. And let's look at Exhibits 12 and 13. What happened on the day of the deposition, really the night of the deposition on January 17th. The President finishes testifying in the deposition around 4 p.m. At 5:38 p.m., the President telephones Mr. Jordan at home. And then at 7:02, the President telephones Ms. Curry at home, doesn't get to her. At 7:02, the President places a call to Mr. Jordan's office. And then at 7:13, he gets Ms. Curry at home, finally, and asks her to meet with him on Sunday. It's vitally important that he meet with Ms. Curry at this point because he knows his whole operation is coming unglued. And so the next day, on January 18th, which is Exhibit 13. Now there's a whole flurry of activity here. I'm not going to go through all of them, but you can see the frantic pace at the White House. Because at 6:11 in the morning, the President had some more bad news. The Drudge Report was released. And that created a greater flurry. Then between 11:49 and 2:55 p.m., 3 phone calls were made between Mr. Jordan and the President. And then at 5 p.m., we see the meeting, that's on the second page, at 5 p.m., Ms. Curry meets with the President, and the President then tells Ms. Curry to find Monica Lewinsky. The telephone calls were generated, and there was no success in that. And then that evening, the President calls Ms. Curry at home to try once again to see if she had found Monica Lewinsky. But it was on that day that there was that critical meeting on that Sunday in the Oval Office between Betty Currie and the President of the United States. And for that reason, we need next to hear from Betty Currie, the President's personal secretary, as to what occurred during that most unusual meeting on Sunday following the deposition. Betty Currie testified in the grand jury that the President said that he had just been deposed and that the attorneys had asked several questions about Monica Lewinsky. And this was a violation of the judge's gag order, and the President, made some comments that were not in line with that. He had some choices to make, and he made the wrong choice. But let's look at Exhibit 14, which covers the series of statements made to Miss Currie at this point. This is the testimony of Betty Currie. She is reciting to the grand jury each of the statements the President made to her after his grand jury testimony. The first one, I was never alone with Monica Lewinsky, right? Second, you were always here when she was here, right? Monica Lewinsky came on to me and I never touched her, right? I'm not going to read each one of those. You could read them for yourself. You've heard those as well. But the President is making those simple declaratory statements to her. There's three areas that are covered here. First of all, the President makes the case that he was never alone with Monica Lewinsky. Secondly, he's making the point to her that she was the aggressor, not me. And the third point he is making, I did nothing wrong. Those are the basic 3 points of those 5 statements that the President made to Betty Currie. During Betty Currie's grand jury testimony, she was asked whether she believed that the President wished her to agree with the statement. Now let's look at Betty Currie for a second. She is the classical reluctant witness. Where are her loyalties as you would examine her testimony? Where is she uncomfortable in her testimony? When she's asked a question, how does she shift in a chair? Those are the kind of ways you have to evaluate the truthfulness of the testimony, where their loyalties lie and where their motives are. But during the question, she's clearly reluctant. But she's asked a series of questions, and she finally acknowledges that it was that the President was intending for her to agree with the statements that were made. She says that is correct. And that is at page 74 of Betty Currie's grand jury testimony. Now, when the President testified in the August 17 grand jury, he was questioned about his intentions when he made those 5 statements to Miss Currie in the office on that Sunday. And the President's explanation is as follows to the grand jury. The President, I thought we were going to be deluged by the press comments, and I was trying to refresh my memory about what the facts were. And then he goes on to testify, so I was not trying to get Betty Currie to say something that was untruthful. I was trying to get as much information as I quickly could. Ladies and gentlemen of the Senate, you have to determine what the purpose of those 5 statements to Betty Currie were. Were they to get information, or were they to get her to falsely testify when she was called as a witness? Logic tells us that the President's argument that he was just trying to refresh his memory is, well, so much of a novel legal defense strategy. First, consider the President's option after he left the deposition. He could have abided by the judge's gag order and not said anything. Secondly, he could have called Betty Currie in and asked a question, an open-ended question. Miss Currie, or Betty, what do you remember happened? The third option was to call her in and to make these declaratory statements, violate the judge's order, and tamper with the anticipated testimony of Betty Currie. And that is the course that the President chose. He made sure it was a face-to-face meeting, not a telephone call. He made sure no one else was present. He made sure that the meeting was on his territory, in his office, where he could feel comfortable and he could utilize the power and prestige of his office, the greatest influence on her future testimony. After Miss Currie was in the President's office, he made short, clear, understandable, declarative statements telling Miss Currie what the story was. He was not interested in what she knew. Why? Because he knew the truth. But he did not want Miss Currie to tell the truth. The only way to ensure that was by telling her what to say, not asking her what she remembered. You do not refresh someone's memory by telling that person what he or she remembers. And you certainly do not make declarative statements to someone regarding factual scenarios of which the listener was unaware. The statements that were made to her, Betty Curry could not have any possible knowledge about as to whether they were ever alone, as to whether she came on to him. No, this was not any attempt for the President to refresh his recollection. It was witness tampering, pure and simple. Understanding the seriousness of the President's attempting to influence the testimony of Ms. Curry, his attorneys have tried to argue that those statements could not constitute obstruction of justice because she had not been subpoenaed and the President did not know that she was a potential witness at this time. Well, the argument is refuted by both the law and the facts. The law is clear that a person may be convicted of obstructing justice if he corruptly influenced the testimony of a prospective witness. The witness does not actually have to give testimony. The witness does not have to be under any subpoena. The witness does not have to be on any witness list. And so the law is clear. Secondly, let's examine the defense in light of the facts. The President himself brought Ms. Curry into the civil rights case as a corroborating witness when he repeatedly used her name in the deposition. And just as significantly, the President had to be concerned about a looming perjury charge against him in light of his false testimony in the deposition. At least 6 times in that deposition, the President challenged the plaintiff's attorneys to question Ms. Curry about a particular issue. You don't have it in front of you, but you will see it when we distribute the copies of my remarks. I'll go through those 6 times. At page 58 of the deposition, the President, when asked whether he was alone with Ms. Lewinsky, the President said that he was not alone with her or that Betty Curry was there with Monica. At page 70, when asked about the last time the President saw Ms. Lewinsky, he falsely testified he only recalled that she was there to see Betty. At page 64, he told the Jones lawyers to ask Betty whether Lewinsky was alone with him in the White House or not, or with Betty in the White House between the late hours. At page 65 of the deposition, the President was asked whether Ms. Lewinsky sent packages to him, and he stated that Betty handled the packages. At page 72, the President was asked whether he may have assisted in any way with the job search. He stated that he thought Betty suggested Vernon Jordan talk to Ms. Lewinsky. At page 74, he said that Monica asked Betty to ask someone to talk to Ambassador Richardson. He asserted Betty as a corroborating witness at least 6 times in the deposition. There is no question but that Ms. Curry was a prospective witness, and the President clearly wanted her to be deposed as a witness, as his Ask Betty questions testimony demonstrates. But there's another very important fact that has been thus far overlooked. And let me draw your attention to this. 2 days before the President's deposition, Betty Curry receives a call from Michael Isikoff, a reporter with Newsweek magazine, inquiring about the records of the courier records of gifts going from Ms. Lewinsky to the President. You've got a news reporter for a national publication 2 days before the President's deposition talking to the President's secretary saying, I need to see the courier records of the White House. What does Betty Curry do? She testified that she probably told the President this. Then she tells Bruce Lindsay, but he also goes to see Vernon Jordan. Why? Why would the secretary go see Vernon Jordan because she had a press inquiry? The reason is, as we see later on, remember, this is January 15th. What happened on December 28th that we'll get to a little bit later? December 28th, Betty Curry went and put those gifts under her bed. Why is she nervous? Because Michael Isikoff is calling about the gifts that are presently under her bed. And she's nervous. I would be nervous. And so she goes to see Bruce Lindsay. She goes to see Vernon Jordan. I need help. What do I do? And she probably told the President. It's all breaking loose. The house of cards is falling down. And she is either going to report to Mr. Jordan or to seek advice from him. Either way, she knows it's serious, and it all has legal consequences, and she is a witness to it all. And not only does Betty Curry's testimony talk about this call from Michael Isikoff and going to see Vernon Jordan, but Vernon Jordan's testimony confirms this visit as well. The President claims that he called Miss Curry into work on that Sunday night only to find out what she knew. But the President knew about the truth on the relationship, and if he told the truth in the deposition the day before, he would have had no reason to be refreshed by Betty Curry. More importantly, the President's demeanor, Miss Curry's reaction, and the suggested lies clearly prove that the President was not merely interviewing Miss Curry, rather he was looking for corroboration for his false cover-up, and that is why he coached her. He needed a witness for him, not against him. Now let's go to Exhibit 5 of Betty Curry's testimony. Excuse me, Exhibit 15. This is Betty Curry's testimony before the grand jury on January 27, 1998. And Betty Curry is asked about this. Now remember, it was on a Sunday that Betty Curry was first called into the White House to go through these 5 statements, this coaching by the President. And then she testified to the grand jury. Question, did there come a time after that that you had another conversation with the President about some other news about what was going on? That would have been Tuesday or Wednesday when he called you into the Oval Office. Betty Curry's answer, it was Tuesday or Wednesday. I don't remember which one this was either. But the best I remember, when he called me in the Oval Office, it was sort of a recapitulation of what we had talked about on Sunday. Quote, you know, I was never alone with her, that sort of thing. Question, did he pretty much list the same? Answer, to my recollection, sir, yes. Question, and did he say it in sort of the same tone and demeanor that he used the first time he told you on Sunday? Answer, the best I remember, yes, sir. And this needs to be emphasized. Not only was that witness coaching taking place on Sunday, but it took place a couple days later. It was twice repeated by the President to Betty Curry. He needed to have her good and in line. This is more than witness tampering. It is witness compulsion of false testimony by an employer to a subordinate employee. This has nothing to do with facts, nothing to do with media inquiries. It has to do with keeping his team on board, keeping the ship from sinking, and the hiding of facts that are important. At this point, we're not talking about hiding personal facts from inquiring minds, but an effort to impede the legitimate and necessary functioning of our court system. And now let's go to Martin Luther King holiday, almost exactly a year ago, Monday, January 19th. And again, you'll see the example of the frantic search for Monica Lewinsky. It continues. Exhibit 16. And I'm not going to go through all of this, but I just want to briefly show the frantic activity on this particular day. First of all, you'll see Betty Curry is trying to fulfill her responsibility to get a hold of Ms. Lewinsky. She uses the pager system and she says, please call Kay at home. Now, Kay is the code name that is used for Betty Curry. That's the agreed upon signal. And she uses 3 messages, please call Kay, please call Kay, please call Kay. Then she starts using different techniques to get her attention. It's a social call. And then she later uses it's a family emergency. Then she later uses it's good news. She's using every means possible to get the attention of Monica Lewinsky. And then at 8:50 a.m., the President telephones Curry at home. At 8:56 a.m., the President telephones Jordan at home. Going down to 10:56 a.m., the President telephones Jordan at his office. And so what is going on here? They're nervous. They're afraid. It is all breaking loose. They're trying to get a hold of Monica Lewinsky to find out what is going on, why, who she is talking to.